The information made available via this podcast is for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Use of and access to this podcast or any of the email links contained within its website do not create an attorney-client relationship between Michael Dockins, Shoemaker, Lupin Kendrick, and the user or listener. The opinions expressed at or through this podcast are the opinions of the individual author and may not reflect the opinions of the Shoemaker firm or any other attorney.
Ladies and gentlemen, welcome to Wrestling with the Law, a monthly ad-free show featuring areas of the law and how they relate to wrestling. Sometimes we'll cover topical subjects that are poignant and relative to the news right now, and other times it'll be historical trials and conflicts and things like that that maybe we're all curious about and you want to hear about from a lawyer's perspective. And that's me. It's Mike Dockins, the Gimmick Attorney, as you might have heard of me on some of Conrad's podcasts. I'm a partner at the law firm of Shoemaker, Lupin Kendrick out of the Toledo office, but we're a firm that has offices in Detroit, Toledo, Columbus, Ohio, Tampa, Sarasota, Charleston, South Carolina, and Charlotte, North Carolina. Today's topic couldn't be more poignant given the news recently. What's an employee and what's an independent contractor, or as I might like to call it, the independent contractor myth in wrestling. This was something we had actually talked about, Conrad and I, for some time and planned it well before Zelina Vega was fired, quit, whatever you want to call it. The timing of this couldn't be better, but like I said, we'd actually planned on this a long time ago, and unfortunately it took a while to get the equipment for all this set up and get it ready to go to be able to put this together. But at least it allowed some updates in real time and to see some of the news and headlines and Twitter and social media reactions to all this news so that I can comment on that as well. So it's important to me, I think, to point out why this goof. Why is he doing this show? Why is he talking about it? Well, the answer is I am a lawyer. I also have a chemical engineering degree, and my lawyer job, my practice, typically is intellectual property. I represent dozens and dozens of wrestlers and some wrestling organizations. But when you go to law school, you don't just go to focus on one particular area. You'll have to take all the regular classes that pertain to all the areas of the law. So I do know a lot about other areas of the law, and I've seen dozens upon dozens of wrestlers' contracts. I've helped negotiate them, help them form businesses, help them deal with domestic things and things like that. So while my typical practice is intellectual property, I do have expertise in other areas and certainly lean on my partners at the firm to get help when it's a little bit out of my depth. But this is something that I personally have interest in, have a passion in, that I have looked into before, and we've even had some debates with the infamous group chat that I'm sure all of you have heard about what is and isn't an independent contractor and does it really apply. So when I talk about some of these things, it may seem like I'm picking on one company over the other. That's because their contracts are different. All their contracts are very similar. I should say not all of them. I have negotiated and seen WWE contracts, AEW contracts, Impact, MLW, and others. So those are the ones that I have personal connections to and personal knowledge of. And they're all very, very similar in very many regards. They are not identical. They trend these days with streaming and things like that towards exclusivity, towards less freedom for the performers, for the wrestlers. Most do allow appearances on wrestling shows, but not on television. So it's an exclusivity sort of thing. It's exclusive to television for that performer, for that company, but they do allow them to do some independent shows and things like that, so long as they're not on TV. Sometimes that gets waived, that gets stretched. And while folks may not be on TV these days, just about any wrestling organization has streaming services, and they stream their shows. They're available on Fight or some of these other networks, and the employers, the wrestling organizations, allow that to happen. But more and more, there's exclusivity. So what does all that mean? We'll get into that in more detail. It's important to note, though, like I said, WWE is different. Their contract does not allow for that. Their contract is very specific to what wrestlers can do inside and outside of the ring. They made the news recently about telling people, as we all know, they can't appear on Twitter, or not Twitter, excuse me, Twitch or Cameo or any of these third-party sort of vendors and monetize their names, ring names or legal names. It was interesting, and they made a lot of news I think it was Stephanie McMahon had said that, their contracts allow the WWE to own the legal name of wrestlers. Well, that's not exactly true. Of course, they can't own someone's legal name. They can control how it's used. This is confusing, and it gets into a little bit of intellectual property, but the reason that WWE can control it is because sometimes people use their legal names in a trademark sense. That is, they're using it to promote goods or services. It's their brand. Typically, you would say their ring name is their trademark. It's their stage name. They're providing services under that name. They might offer shirts and action figures and things like that. Of course they do, but that's made up. But that can also be your legal name. There are plenty of celebrities, actors and actresses and singers that have trademarked their legal names on particular goods and services. So WWE can control that. They can tell people you can't do these things under your name, but WWE doesn't own legal names. That was a misstatement, wasn't true, wasn't accurate. So the question about whether someone is an employee or an independent contractor, first you have to kind of step back as an employer, WWE, AEW, Impact, one of these, and ask, what is this person? What are they doing? How are they providing services for me? And there's actually more than just employees and independent contractors. We'll get into those in more detail, obviously, in a minute. But there's also something called a statutory employee. And I'll come back to this full circle when we get done with the show, but it's important to point out now some of these things, and you'll see why later. A statutory employee is an independent contractor, but under the law, under the common laws, they're treated as employees by statute. Now, what does that mean? Well, first of all, it doesn't mean much because it only applies to a certain number of categories of workers. Very narrow circumstances, does not apply to wrestlers, at least not yet. One area that you can be a statutory employee is the driver of beverages that aren't milk. Why milk was carved out of that, I don't know. But, if you're a soda driver or a bottled water driver, something like that, and you're delivering those things or delivering meats, vegetables, fruits, bakery products, or laundry and dry cleaning, you could be a statutory employee. Full-time life insurance agents, sales agents under certain conditions. Again, don't need to go into those details, but that's a class of employees or workers, I should say, that could be a statutory employee. Also, individuals who work at home on materials or goods with which they are supplied and that must be returned so long as the specifications for the work are provided. So in short, people who work at home who are given the materials in which they're supposed to do something with, create something, the specifications, the directions are given to them, and then they return it to the person who made the order. And then full-time traveling or city salespersons who turn their orders in from wholesalers, retailers, contractors, or operators of hotels. So again, none of that applies to wrestling, but it's important to point out that is a type of employee or type of worker. So if you are one of those types of workers, it only applies, again, under certain more conditions. Services performed have to be done personally by that individual. Certainly that would apply or could apply to wrestlers. The worker does not have substantial investment in equipment and property used to perform the services. Now, if I were WWE, I would argue, or not just WWE, Impact, AEW, all these places, that some of the equipment, some of the property used to perform services includes, makeup, ring gear, boots, and things like that. Certainly those companies don't own those sorts of things. But I would argue, I think that the talent would argue that the substantial investment in equipment and property really is talking about entrances, rings, barricades, barriers, lights, things like that, that they just, the wrestlers just don't provide. So again, it could apply to wrestlers here. And services are performed on a continuing basis for the same employer or the same payer. Again, boy, that sure seems like it would apply to wrestlers if they fell under one of those 4 enumerated situations. They don't, at least not yet. Now, assuming you're one of the categories that's allowed to be a statutory employee, assuming you meet those categories of how the services are provided, where they're provided, investment, etc., then what happens is the company will withhold your Social Security and Medicare taxes. The company, the payer, has to pay those taxes as well. So you split the taxes. That's one category, statutory employee. And there's another one called a statutory non-employee. Again, it only applies in certain circumstances, direct sellers of things, licensed real estate agents, certain companion sitters, they're treated as self-employed. So essentially they're treated as independent contractors, but they're not. They're called a statutory non-employee. And last, government workers, public officials, elected officials, public officers, they're all treated differently from employees, from independent contractors. They're treated, again, under the tax purposes. And really, at the end of the day, that's what this is about, tax purposes. There's benefits and things that come into it, and you'll hear why. But by and large, it's a tax consequence sort of thing. And the IRS is who is deciding this, who's telling us, yeah, you're a contractor, you're not a contractor. And if you are, then this set of rules applies. And if you're not, then that set of rules applies. So, there's the famous story of Al Capone. Al Capone didn't get caught having people murdered and things like that. He got caught for evading taxes, which I think is where the origin or kind of the belief of the two things you can't avoid are death and taxes came from. The tax man always comes and he always gets his man. Don't tell Ernar Shyster that. But so let's jump into the two big ones. Let's jump into what is an employee? How is an employee defined? And are wrestlers independent contractors? As most of you probably know, and maybe if you don't, John Oliver on Last Week Tonight, sometime last year, talked about this. He delved into it in depth and used his humor and charm to kind of take on the WWE. Again, not trying to pick on them specifically, but they're the biggest dog. They have the biggest target. That's what happens. He didn't think so. And Jesse Ventura sure didn't think so. And Jesse was on the Howard Stern show, and John Oliver borrowed from that and took on WWE and many other prominent wrestling promotions. So I'm inclined to agree. Frankly, I'm inclined to agree with John Oliver and Jesse Ventura that they're not independent contractors, but here's their thoughts.
While you might reasonably think that the wrestlers employed by him are his employees, they're actually not. They're merely independent contractors. Which, as former wrestler Jesse Ventura pointed out on Howard Stern, is just insane.
How are they self-employed when you're signed exclusively?
Right.
You can't work for nobody else.
It's a monopoly.
Yeah. They tell you when and where you'll work. They tell you who you'll work. They can totally control your life.
And you're an independent contractor.
And yet they call you an independent contractor. How has the government allowed them to get away with that for 35 to 40 years?
Yeah, he's got a point there. An independent contractor is someone that you might hire for a specific limited task, like a plumber or an accountant. Wrestlers aren't either of those things, apart from this wrestling plumber and this wrestling accountant. But the vast majority are totally different.
Okay, so hopefully you enjoyed that. John Oliver's pretty funny, and Jesse Ventura is pretty to the point. I think he gets it across pretty clearly and cites some very important facts, some things from somebody who is inside the room. So let's look at in depth what the IRS says, right? What does the IRS say is an employee? The IRS says under common law rules. So common law rules are the rules of the land kind of made up by, not by statute, not by code, but by case law and how things have just worked out over years of evolving law in the cases. Under common law rules, anyone who performs services for you is your employee if you control what will be done and how it will be done. This is so even when you give an employee freedom of action. That is to say, you don't have to micromanage them down to the every minute detail of what they're doing and how they're doing it. You could say, hey, John, hey, Susie, go do this, create this event, set it up and run it. That's good enough. That's an employee, even though they have some freedom of action. What matters the most is that you have the right to control the details of how the services are performed. That is straight from the IRS. So that's pretty broad, pretty vague, but certainly you have a little more detail than that when it comes to independent contractors. So what is an independent contractor? It's a worker who individually contracts with an employer to provide specialized or requested services on an as-needed or project basis. So the individual is free from control, free from direction of the performance of their work. So that kind of creates a conflict, at least in my mind with wrestling. How does that work? You have to have a coherent storyline. You have to have coherent messages and kind of a theme to the show. At least the wrestling that we grew up on, there's kind of this theme and underlying storylines and things that may weave together and don't. Those things notwithstanding, what about in today's wrestling where there's scripted interviews? What about where there's specific finishes, where they are told this is how it's going to end? It's going to end at this time period, and this person is going to win or not win. It's not like, at least as we're led to believe, kind of how it was back in the day, where the booker would come to you, say, hey, hey, Bullet Bob, hey, Jerry Lawler, this is what we're doing. This is how it's going to end. You've got 15 minutes. Have fun. And let them go on their way and figure it out and tell the story that they kind of wanted to tell in the ring. What about ring gear? What about names? Who decides that? So while I may be, as a wrestler, required to provide my own ring gear, I may have to pay for it and bring it in. I'm not allowed to just wear whatever I want. I'm going to be told that something can or can't be worn. Certain colors can or can't be worn. So there's certainly very little control and a lot of direction, or so it would seem, on ring gear and even names. Folks aren't necessarily allowed to come in as the name that they had used and maybe got famous for on the independent scene. They might have to change their name. They might not be allowed to use their legal name because, as we know, Kevin Nash, Scott Hall, those guys really made it popular to go by your real name. So an independent contractor, that's kind of the very broad description of what it is. And again, our friend John Oliver took that on. He gave his definition, and let's hear what he had to say.
For instance, the IRS states that independent contractors should be free to work when and for whom they choose. Well, Vince's wrestlers sign exclusive contracts, so that's complete bullshit. The guidelines also say that someone's probably not an independent contractor if the success or continuation of a business depends to an appreciable degree on the services they provide. Now, I guess the question there is, are wrestlers essential to world wrestling entertainment? It's a good question. I mean, it's not called World Totally Empty Ring Entertainment, so that might be a clue. In fact, if I might quote the company's own website, WWE performers are the company's greatest asset. Without our performers, WWE would not exist.
So there you go. That's what John Oliver had to say. What about the IRS? Again, when it all comes down to it, that's what it comes down to. What does the IRS say? What do they think? The IRS says the general rule is that an individual is an independent contractor if the payer has the right to control or direct only the result of the work and not what will be done and how it will be done. The earnings of a person who's working as an independent contractor are subject to self-employment tax. So you're paying your own taxes. The IRS also says you are not an independent contractor if you perform your services that can be controlled by an employer, what will be done, how it will be done. And this applies even if you're given freedom of action. What matters here, what the IRS says matters here, is that the employer has the legal right to control the details of how the services are performed. The IRS also says if an employer-employee relationship exists, and this is the part that absolutely crushes any arguments I've heard, including some in cases that we'll talk about. And if an employer-employee relationship exists, regardless of what the relationship is called, one is not an independent contractor and earnings are not subject to self-employment tax. So that is to say, if you have a contract, for example, a booking contract, a talent agreement, and that talent agreement says, hey, you're an independent contractor. You agree that you're an independent contractor. Well, the IRS says that doesn't matter. It doesn't matter what you call the relationship. What matters is what's actually happening. How are you actually being treated? That is straight off the IRS website. So what is an independent contractor? We've kind of danced into very broad things, but there's actually some specific rules, specific guidance, again, set forth by the common law or set forth by the IRS, more importantly, that says what an independent contractor is. So common law rules, facts that provide the evidence of the degree of control and independence generally fall into three categories. And we'll talk about specifics here in a minute. But the three categories are behavioral treatment, financial treatment, and the type of relationship. So what do we mean by behavioral treatment? Does the company control, or does the company have the right to control what the worker does and how the worker does his or her job? Financial, what does that mean? Are the business aspects of the worker's job controlled by the payer? These things would include like how the worker's paid, whether certain expenses are reimbursed, who provides tools or supplies or equipment, that sort of thing. Type of relationship. Well, what does that mean? Are there written contracts or employee type benefits like pension plans, insurance, vacation pay, and that sort of thing? And will the relationship continue? And is the work performed a key aspect of the business. You tell me, are wrestlers in All Elite Wrestling and Impact Wrestling and World Wrestling Entertainment key to what they're doing? Sure seems like it. So the IRS gives us some guidance, and there will be a link to this in the show notes. There's a lot of different people who lay it out a lot of different ways. You can find it on many, many, many different websites. The one I'm citing to is kind of a checklist. I like how it's laid out, but you'll find basically the same thing everywhere. So look at that if you want to see the checklist, but we're going to go through it. These are some factors that indicate whether an employee or not an employee, an independent contractor, is an independent contractor. When you look at the checklist, when you look at the IRS 20-factor test, there's no magic number. I can't say that if you meet 5 and don't meet 15 that you are or aren't an employee. Nobody can. Not even the IRS would do that. No one factor of these 20 stands alone. It's not more important than another one. It's not more important than the next one. And it may not be important at all, because in some instances, including maybe in wrestling, the factor might not apply. So this is just 20 factors, but the IRS will say, if you go through this and you find that more of the answers are yes, you're probably an employee. If more answers than not are no, you're probably an independent contractor. So we'll go through them. We'll go through the 20 factors, and you tell me, you think in your head, you answer these questions to yourself, knowing that all companies, at least all companies that I'm familiar with that have talent agreements, allow their talent to wrestle on the independent scene. They allow them to do things for other companies. You've seen it on AEW. You've seen Thunder Rosa and others appear from the NWA. And that's on television, right? So that's contrary to her contract. But again, the promoter, well, not again, but the promoter can change. People can change the contract based on agreement, based on, hey, this would be good for both of us. Let me do this. Okay. AEW, Impact, MLW, Ring of Honor, all those guys, they allow you to appear on independent scene, maybe without television, maybe without streaming. It depends. WWE does not. So when you go through this 20 factors and you go through step by step, you can kind of delineate sometimes they're exactly the same, whether someone's an employee or whether someone's an independent contractor. So step one, or not step one, but factor one, instructions. Is the worker required to comply with the employer's instructions about when, where, and how to work? Again, is the worker required to comply with the employer's instructions about when, where, and how to work? I think we know the answer to that in all instances. Training. So is training required? Does the worker receive training from or at the direction of the employer, including attending meetings and having to work with other experienced employees, an agent, perhaps? Integration. Are the workers' services integrated with the activities of the company? Does the success of the employer's business significantly depend upon the performance of services that the worker provides? I mean, come on. Are the workers' services integrated with the activities of the company and a wrestling company and their wrestlers? I think the answer has to always be yes there. Does the success of the employer's business significantly depend upon the performance of services that the worker provides? Again, I don't see how you can come down any other answer but yes. Services rendered personally. So is the worker required to perform the work personally? I think we've only got a couple of instances of the same gimmick, the same name, the same trademark being used on different performers. So fake Diesel, fake Razor. How'd that work out? Certainly under a mask, it could be argued that there's been a number of different doinks. There's been different enhancement talent that have worn a mask and maybe had the same name. That's great. That's a couple, that's a handful, and they haven't been that successful historically, doink notwithstanding. I think the answer has to be, yeah, when I hire you, or you have a gimmick, or you have a name, I want you to do it. I'm not going to traipse out Hulk Hogan to pretend to be the Ultimate Warrior and say he's the Ultimate Warrior. Jim Hellweg or Warrior has to do the work himself. Authority to hire, supervise, and pay assistants. So this one probably doesn't apply in the wrestling context, but the factor is, does the worker have the ability to hire, supervise, and pay assistants for the employer? I mean, I think the answer is no. I don't know that any wrestlers are allowed to hire or do any sort of supervising or assistant employing for the WWE or AEW or Impact. But in this context, I don't know that factor 5 really applies. Factor 6, continuing relationship. Does the worker have a continuing relationship with the employer? Well, you tell me. These guys are under contract. They're usually years at a time. They're on TV most, if not every show. They have appearances on pay-per-views and things like that. Factor 6, continuing relationship. Does the worker have one with the employer? Sure seems like it. Factor 7, set hours of work. So is the worker required to follow set hours of work? Are they told they have to be certain places, certain days, at certain times? Will there be repercussions if they're not there for that? I dare say in most instances, I think we know the answer to that. Is full-time work required? So does the worker work full-time for the employer? Again, this one might not apply. Maybe if it does apply, the answer is no. What is full-time? I think it's probably set by statute, certainly by wage and hour laws, because if you're above a certain amount, you have to be paid overtime, whether you're exempt or not exempt. Again, doesn't matter for our purposes here today. So they probably not full-time employees or full-time workers for the employer. Factor 9, place of work. Does the worker perform work on the employer's premises and use the company's equipment? Again, that seems pretty straightforward to me as to the answer to the question. Factor 10, sequence of work. Does the worker perform work in a sequence set by the employer? Does the worker follow a set schedule? Well, I think it's come down this week that there might not be house shows in the future, but when there were house shows, some of my clients certainly worked a loop where they would get up on Friday morning. They would head to whatever town they had to work. They would work Friday. They would work Saturday. They would travel Sunday or have a show Sunday. They'd show up at TV on Monday. They'd show up at TV on Tuesday. They'd go home on Wednesday. So they'd be home half day Wednesday, full day Thursday, leave again Friday. And that was their lives for years on end. Seems like a set schedule to me. Reporting obligations, factor 11. Does the worker submit regular written or oral reports to the employer? Again, I don't know that this one necessarily applies. I think it applies for agents. And I think agents for most companies probably are employees. But for wrestlers, I don't know that it applies. And if it does apply, I think the answer is no. Factor 12, method of payment. How does the worker receive payments? Are there payments of regular amounts at set intervals? I think it depends on the size of the company as to whether or not that would apply. Certainly the larger companies have, I don't want to say salaries. They have a contracted amount in which they have to pay a talent, and that is broken down in the contract how it's going to be paid every 2 weeks, monthly, so on and so forth. This is different from, of course, the territory days where we hear about guys getting payouts that day, and it wasn't a regular amount. It depended on the show. It depended on the house. It depended on where they were on the card, and you could travel and get paid $500 one night and $200 the next. So this is kind of a difference, kind of shift in how things have worked. And nowadays, I think it's much more towards the regular pay, regular interval sort of thing, especially when you're one of the top companies. Payment of business and travel expenses. It's factor 13. Does the worker receive payment for business and travel expenses? Again, I think it depends. Depends on the company. In AEW, I think a lot of those things are covered. In WWE, they are not covered, but sometimes they are covered. That's all a contractual sort of thing. It's all negotiated. We hear all the time about guys saying, hey, I'm not going to fly anymore. I want a bus. I want you to buy me a bus. I want you to pay the driver, or buy me a bus and I'll pay the driver. And it's all part of the negotiation. But Joe Blow walking in off the street, maybe has a little bit of indie cred. He doesn't get that deal. John Cena's get those deals. Undertakers get those deals. So again, it's going to depend. It's going to depend on the company. It's going to depend on the circumstances. By and large, historically, I think we know and have heard the talent, they do not get reimbursed for those sorts of things unless they've negotiated for it. The default position is it's not. Factor 14, furnishing of tools and materials. Does the worker rely on the employer for tools and materials? Does that apply here? I don't know that it does. Some would argue, I would argue, especially if I wanted to, that the tools and materials would be the ring, would be the entrance, would be the pyro, would be the lighting, all of that. That's all stuff that I need as a performer to put on the best performance I can, and in the instance of a ring, the only performance I can. So it could be argued that, yeah, the worker does rely on the employer for that. Now, if we're talking about ring gear, makeup, gimmicks and things that you bring, cigars and hats and all of that, then, maybe the answer is no. So it depends. It really is going to depend who's looking at it and what they want to classify as the tool or material. Investment. Has the worker made an investment in the facilities or equipment used to perform the services? Again, how are we going to define that? You tell me. How do you want to define it? If we're talking about equipment used to perform the services being rings and things, no, of course not. Of course, the talent's not investing in that. But you can't have it both ways between 14 and 15. If you define it one way where it's all inclusive, including ring gear and things like that in 14, then I think you have to in 15. So certainly the talent, the worker, has made an investment in wrestling gear. They have made an investment in their bodies. Does that count? Is that an equipment used for the performing of the services? I could argue that it is. Certainly that's something they're able to write off on their taxes as an unreimbursed business expense, because they have to go to the gym, because their contracts often say your appearance matters and we can fire you if your appearance falls off for any reason. For reasons that we don't have to explain to you, we can fire you because we think you're out of shape. So again, I could argue that they have made a significant investment in their equipment. Risk of loss. Is payment made to this is factor 16, risk of loss. Is the payment made to the worker on a fixed basis, regardless of profitability or loss? I think the answer is yes. I mean, of course, they can be fired, and they can be fired on a whim so that there's a severance package, and then that stops. But folks get paid what they get paid based on their contract. They might get bonuses as well. But regardless of profitability or loss, they have guaranteed minimums. They have guaranteed salaries. Again, that's kind of the WWE thing. AEW and places like that. It's not necessarily this famous, we've all heard the stories about, all I can offer you is a chance, pal. It's they go out there and they get paid based on a negotiated amount. It's not necessarily a minimum, bonuses notwithstanding. This is a big one. Factor 17. I love this one. Working for more than one company at a time. Does the worker only work for one employer at a time? Depends on who you're asking. Who am I looking at? Who am I reviewing? Am I reviewing WWE? Because if I am, the answer is yes. They're not working for anybody else. They could have WWE fallen back on, well, they're working for themselves because they're doing Twitch, they're doing Cameo, they're doing all these outside things. They're appearing on The Mandalorian, although that was probably through WWE. But the other companies can say, no, they don't work for just one employer. They work for all kinds of places. They're allowed to be here at AEW and go to GCW and CZW and any of these other things. They're allowed to do those things. Now, there are restrictions on that, and we could debate and argue whether or not they're truly free to work for somebody else, or if they have to get permission and it's just kind of an exception. I'm not here to argue that. But depending on who you look at for the company and the circumstances will dictate how you answer that question. Factor 18, availability of services to the general public. So are the services offered to the employer unavailable to the general public? Well, I mean, I'm not sure what that means, so I don't think that it really applies. Does the general public need wrestling services? I mean, I guess the service is being provided to the general public. So that one's quirky. I don't think that one necessarily applies. Factor 19, the right to discharge. Can the worker be fired? Can the worker be fired by the employer? Yes or no? Well, I think we all know that they can all be fired. They even under their contracts, there's an out. They're allowed to be fired at any time. They're kind of an at-will independent contractor. So I think the answer is yes, no matter who they work for. And number 20, the right to quit. Can the worker quit work at any time without liability? Now, how's liability defined? Do they have to pay damages or something like that? Well, I think in most instances, no. But if a worker quit, it's in the middle of a heavy storyline right before WrestleMania, right before Full Gear, something like that. Would there be liability there? Sure, I think there would be. Are they able to freely quit working and immediately go work somewhere else? No, they're not. Brock Lesnar was blocked out for a substantial amount of time the first time he left WWE, where he couldn't, not only could he not go wrestle, but he couldn't do MMA. And that was kind of part of why he went and followed his football dream for a hot minute, is that he was boxed out from not only sports entertainment, but actual combat sports. And if I remember correctly, and correct me if I'm wrong, I think it was not only here, but also Japan. Normally in a non-compete, what you're looking at is it has to be reasonable in scope, it has to be reasonable in length of time, and it has to be reasonable in geography. And then if you sign one of these things and it's unreasonable in any of those ways, of course you have to challenge it. And that's expensive. So it's not necessarily something that everybody's going to do. So now we've gone through the factors of what makes an independent contractor. Why does the WWE, why do wrestling companies and promoters want their workers to be independent contractors? Well, there's a lot of reasons. And as you can imagine, a lot of it has to do with money. So why independent contractor? There's no workers' comp benefits. There's no unemployment tax that has to be paid. There's no Social Security or Medicare taxes, also called FICA taxes, because the way that works, in case you don't know your own taxes, and in case you're an employee, is that there's at current rates, that tax, your FICA tax, your Social Security, your Medicare tax is about 15.3%. And you pay for half of that, and your employer pays for half of that. When you're an independent contractor, you pay that full 15.3% yourself, because you're both employer and employee working for yourself. But in case you wonder the numbers, to nerd out on some of that, Social Security tax is about 6.2%, and Medicare taxes are about 1.45%. So it's a total tax of 7.65%, 15.3 total. So why would a promoter want you to be an independent contractor? Because I'm going to save 7.65% of whatever you're getting paid that I now don't have to pay on your behalf to the government. No benefits. There's no health care. There's no 401k. There's no retirement plans. Independent contractors, generally speaking, you don't have to pay for travel expenses or equipment like gear. And employers for independent contractors are exempt from wage and hour laws, employment discrimination laws, and unemployment insurance. So again, money, money, money. So our friend John Oliver, I know I've hit him up a couple times, but he talked about this as well. He addressed this last year, and he even quoted some of WWE's own filings. Take a listen.
Independent contractors. Wrestlers are exempt from most discrimination and occupational safety laws. They also don't get paid annual leave, pensions, or health insurance.
So why would talent be okay with independent contractors? Why? What's the plus side? It seems like I'm just dumping on it about all these reasons that seem terrible and why nobody would want it. What allows for higher contracts, right? Because there's no benefits, there's no taxes withheld. It's a much higher upside, but at the end of the day, as I talked about at the top, the IRS always gets their money. It's just a matter of who's going to pay it. But if you don't have all these employment laws and all these wage and hour laws and all these sort of discriminatory practice things that you have to worry about, and I'm not talking about necessarily race or age or gender or things like that, that's always going to be protected. But you can treat different people differently. Top card, mid card, top of the mid card, bottom, enhancement talent. You can treat all those people differently. And if you were to go from an independent contractor to a employee sort of relationship, what's going to happen to those contracts? If you're starting out at 100, 125 as a guy first going to the performance center or just going to the wrestling school that works the promoter, and you are making 125 flat and you got to pay all your taxes, great. Good for you. That's what you get. You pay your taxes on that. But if you're an employee now and there are all these extra costs, you have all these insurances and Social Security taxes and all these withholdings and all these new rules and benefit plans and 401ks, you're going to see those salaries go down. Independent contractors, it also gives you a lot of flexibility in bonuses and merchandising deals. It doesn't hold a lot of water with me because all that can be dealt with contractually. All the time, employees, maybe not sort of middle management, but CEOs and this sort of thing, negotiate their bonuses. They negotiate their benefits. They negotiate the things that they get a cut of in performance. Hey, if my t-shirt's performing at such a high rate, I should get more of that money, and here's how it works. That can all be dealt with. So being an independent contractor, at least as far as I can tell, and in my opinion, it appears to be better for the top guys and not necessarily for the mid-card guys and the low guys. And by guys, I mean guys and gals, of course, the talent. It appears to be best for the top talent. And I think if you're to believe Jesse Ventura and all of that, Hulk Hogan squashed the idea of unionizing and protecting things that Jesse was putting forth in the 80s, and that caused their rift. But Hulk was a top guy. He was making the most money, and his success meant everybody else's success. People wanted to be on his card, wanted to be on his show. And so he was able to kind of work people, hey, this is better for us. We're going to get more money. There's going to be more flexibility, kind of damning the idea of healthcare and things like that. Nobody in their 20s and 30s thinks that they're going to get hurt and there's going to be these long-term ramifications. Let's think about what it's going to be like when we're in our 60s. They weren't really thinking about that. And maybe if they had been, things would have been different. But at the same time, in the early 80s, when wrestling was still territories, it was very much independent contractors. I think you could go through that 20-factor test and do an analysis based on 1970s wrestling, early 1980s wrestling, late 80s wrestling. But by the time you get into the early 90s, mid 90s, late 90s, and certainly into the 2000s, that all changed. Everything about that changed. How wrestling was done, how wrestling worked, and the money involved, of course. And so it makes some sense to me that it kind of got squashed in the early 80s. You did have more flexibility and all of that. But nowadays, man, I'm just not sure. So like I said, I know it feels like I'm picking on WWE, and I certainly don't mean to, but they have positioned themselves differently from all the other companies that I'm familiar with. What do they say about independent contractor status? Well, they themselves have said WWE talent are highly skilled professionals who only perform and promote their appearance. Unlike employees, they do not have any corporate responsibilities or duties, and thus are independent contractors. As independent contractors, WWE talent is able to negotiate all aspects of their contract, including the length of the agreement, compensation, time off, disability provisions, and other benefits that would not be afforded to an employee. Boy, I mean, maybe that's the case. I certainly haven't represented every wrestler that's ever wrestled for them. But people that I have represented, they were not able to negotiate the length of their agreement to any meaningful degree. They were able to negotiate their compensation. Again, it depends on where on the card you are. Time off, not really. Disability provisions or other benefits, maybe. Not that I've seen, but maybe it's there. So how has wrestling gotten away with it? Well, I kind of talked about that a minute ago. The territory days, it was very different. It was very much independent contractors. There was less scripting. There was more freedom of travel and to appear in other territories. And, guys could be in the Mid-South territory one week and be allowed to hop and go up north, go to Memphis and wrestle there for a little bit. They were allowed to do things more like independent contractors. They were given a finish and they were told, go out there and end it. Go get the heat. You're the heel. You're the baby face. Go for it. And they didn't always have long-term gigs in any one place. They'd have a storyline or two or three. And, if you listen to Jim Cornette's podcast, he and the Midnights would be certain places for 6 months, a year, whatever. They'd have some big, huge storyline, just get crazy, people chasing after them with knives kind of heat. That would all end and die down. They'd go away. They'd go away to go to a different territory, do the same kind of thing there, and then come back. Circle back and get that heat again. And that is an independent contractor. Again, our friend John Oliver, he talked about it. Let's see what he had to say.
Maybe when wrestlers might work years ago for multiple different organizations, it made sense to call them contractors. But now that WWE has a chokehold on this industry, it makes just as much sense to call them that as it does to call Jimmy Carter a panty-dropping machine. It's just clearly not true anymore.
So you go. John Oliver and I agree. So in short, the business has evolved. So it's important to also talk about how WWE, how promoters have gotten away with this. How have they gotten away? Like they're breaking the law. This has been litigated. It's been tested. It's been challenged. I don't know how recently in some instances, but it has been. But the IRS provides a safe harbor. They provide a reasonable basis test. The reasonable basis test provides a safe harbor for employers that bars the IRS from challenging the independent contractor status if certain conditions are met. So one condition is the employer has to have always treated the worker as an independent contractor. Another is the employer has filed all of its returns for that particular worker since 1978, so 78 and after. All those returns filed by the company were consistent with independent contractor status, and the employer has, here we get the name of the test, the reasonable basis for treating workers as contractors by relying on something. And that something can be judicial precedent. It can be published rulings or technical advice. It can be a prior IRS audit showing no penalties assessed for similarly situated workers, or it can be longstanding recognized practice of a significant segment of the industry. How about that one? How about that one for why any company, WWE or otherwise, has a reasonable basis for treating its workers as independent contractors? A long-standing recognized practice of a significant segment of the industry. AEW certainly put things on its ear when it got created in 2019. They said, hey, we're going to have some workers that are employees. It depends on where they are in the office, where they are positioned within the company, but it can be an employee / worker. Triple H is treated as both an employee and, used to be anyway. I don't know if he's still performing, but was treated as an employee for his office work. And then he had a talent agreement that was treated as an independent contractor. But aside from those very recent things, I'm not familiar with any wrestlers that have been treated as employees. But even if there have been, and I'm sure there have been at some point or another, the test is a significant segment of the industry. Well, I think that the vast majority, or better, an overwhelming majority, has been treated as independent contractors, and as such, there's a reasonable basis. So that's how and why that they have been treated and continue to be treated as independent contractors. So an interesting case happened in 2009. It was brought by Raven, Canyon, and above average Michael Sanders. They filed a suit. Part of it, there's a lot of things that were in it, but one of the major things, the thing that made headlines, was that these guys claimed employer-employee status. It's important to recognize they lost this, and I think they lost this more or less on technicalities and gamesmanship. But it's important to point out that WWE contracts, and this is not picking on them because contracts that my clients here in Ohio have will typically have Ohio as the choice of law. It's usually where the business is situated, formed. Doesn't have to be, it can be anywhere, but most of the time it's going to be where the business is formed, where they're situated, where they reside. So WWE contracts have a choice of law provision. It's going to be Connecticut law, and a venue provision. This is going to happen in Connecticut. Well, I mean, I don't know for certain, but I can't imagine there are too terribly many Connecticut companies and businesses that generate more income and tax revenue and have political sway like WWE does in Connecticut. So they're already in a very favorable place with favorable rules that I'm sure that they have lobbied and helped set into place. So that's an important thing, gamesmanship. But it's not. I'm not picking on WWE. That's what all contracts say. That's what everybody does. This idea that you can negotiate that, of course, is nonsense. If you were a performer going to WWE and you said, well, I mean, that's great that you have Connecticut, but I live in Indiana. I want Indiana law and I want it to be fought in Indiana. No, they're not going to do that. They would never do that. They'll never consider that. It will be in Connecticut, or, you don't have to work here. So I don't know how much freedom for negotiation there is. And in fact, I do know, and it's none with respect to that one. But the court found at the end, when they made their ruling, impertinent part, the court said the booking contracts that outline the terms and the conditions of the relationship between WWE and each wrestler specifically stipulate that plaintiffs are independent contractors. Furthermore, plaintiffs cite no authority to support their employer-employee claim and did not show that the booking contracts were invalid. So the court said, hey, we're just not going to look at this because you've agreed by contract that you're an independent contractor. You've agreed to it. You went into this knowing this, and so you can't be heard to complain now. I mean, that's true, but we're talking about a situation where there was no bargaining power there. You have no ability, particularly between, say, 2001 and 2019, to negotiate anything. There was one big dog, and everybody else was just picking up scraps. They were small companies, small promoters, maybe regional, maybe very successful. I'm not impugning them, but WWE was it. It was not a monopoly, but boy, it was something that looked like a monopoly. And you can't negotiate that. You can't say, well, I want to come work for you. WWE. I really do. But man, I don't want to be an independent contractor. I want to be an employee. They're going to say no. The answer is no. You're either an independent contractor or enjoy, small town wrestling league. See you later. So that wasn't really looked at. And as the court said, they cited no authority to support their employer-employee claim. Well, no, they probably didn't, but they probably could have. The thing about fighting the giant with bottomless pockets is that they're a giant with bottomless pockets. And as an independent contractor who was, mid-card or maybe at the top of the card of a smaller group, you don't have the resources necessarily to fight a prolonged battle against that giant and pay your attorney's fees. So I don't know that they could have gotten into it. But let's remember that at the top of the show, I talked about from the IRS's own website, from their own provisions, that if there's an employer-employee relationship, there's an employer-employee relationship, no matter what you call it. Why that wasn't cited, why that wasn't argued, I don't know. But I think those things are about to change. So what now? What do we do now? What do the wrestlers do now? If they want to challenge this employer-employee relationship, if they want to say, hey, we're not doing this anymore. We're not independent contractors. Well, I think they've got a few choices. And there's been some things that hit the news cycle, I should say, very recently that give some hope, give some options if people want to be employees. There was a California law that was passed in January 1st, 2020. A new California bill gave some hope to some wrestlers. The law in California was that an independent contractor is presumed to be an employee unless stringent requirements are met. So the requirements included the codified so-called ABC test for determining whether a worker is an employee or a contractor. All of the criteria must have been met to be considered an employee. So what are those criteria? It's pretty straightforward, and it's going to sound familiar to things we talked about earlier. Is the worker free from control and direction in connection with the performance of the work? Does the worker perform work outside the usual course of the hiring entity's business? And is the worker customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed by the hiring entity? So I think you probably would have, in California, been deemed an employee, even as an independent contractor. But of course, on September 4th, new legislation passed that provided additional exemptions to the presumption of an employee status. And those additional exemptions, the most relevant one, of course, was performance artists. And I think any pro wrestler now, sports entertainer, would have a hard time saying they're not a performance artist, that they're something else. So that law kind of got neutered. Doesn't mean it's not going to be challenged. I think that's going to shift and evolve constantly. And if they do ultimately say, hey, the ABC test stands up and performance artists can be treated as employees, I think you'll see shows not happening there is what I think will happen. Then I think you'll see significant revenue lost for hosting, say, a WrestleMania or some other pay-per-view. And so those laws will change because the dollar always speaks. Another possibility, I don't think it's ever been raised. It's something that I could see being done, is to try to get the IRS to get the tax code changed to include a new class of statutory employees that would include wrestlers or performing artists of some sort. If we can talk about beverage delivery services that don't include milk, I don't know why you couldn't have a specific carve out for professional wrestling. You could. That would certainly save wrestlers money because they wouldn't have to pay both portions of the FICA taxes. But it doesn't resolve retirement. It doesn't resolve healthcare and those sorts of issues. So it's not really a solution. It would just save the talent a little bit of money. This is a big one, though. The next one, the National Labor Relations Board review. This is good because you don't have to hire a lawyer as a wrestler. It's not a company favorable venue sort of thing. It's not a choice of law sort of thing. It's a government agency reaching out and looking into something. Now, can they be influenced? Of course, particularly if you've got, a wife on the cabinet. But generally speaking, theoretically speaking, that shouldn't be the case. And it should be a wholesale review of what's going on. And is there actually something going on? In fact, the former 2020 Democratic presidential nominee, Andrew Yang, recently made a lot of waves and has been hitting the talk show circuits and podcasts and things like that. he took great umbrage and has now taken it upon himself to make it a cause that he's championing, that he got upset when WWE said, hey, you can't perform on Twitch. You can't perform on Cameo. And in some instances, if you're to believe Zelina Vega, she made more money on Twitch than she made in her contract. He said, hey, if Joe Biden wins and I'm tapped to be labor secretary, something I'd love to do, I'm going to address this. I'm going to address WWE specifically, is who he cited. And he's cited AEW as at least having some employees covering some travel expenses and things like that. But if he's labor secretary, he's going to address this. He's going to address WWE's behavior. And if he's not the labor secretary, then he is going to work with whoever the labor secretary is to try to initiate the NLRB review. He provided some of his thoughts, some of the things that he think would be interesting on a recent appearance with Chris Van Vliet. Let's hear what they had to say.
So are you looking to perhaps become a part of this? You looking to become the labor secretary?
Well, I'll do one of a number of things if Joe and Kamala will have me. But one of the things I said in my tweet was like, look, even if I'm not the labor secretary, can I call the labor secretary? Will I know that person? Sure. Can I call the people who are the new appointees to the National Labor Relations Board? Yes. Like, will I forget about this? Hell no. And that's part of it, is that like Vince and the gang, they buy because they're like, well, the mainstream press won't pay any attention to it because it's wrestling. And the wrestlers can't say a damn thing because they know we'll come down on them like a ton of bricks. So let's just keep exploiting people and making our millions, and we'll just get away with it for decades and decades. And the bill's coming due. I'm going to be the person that does it, or the person that is there when it's done. And it's going to give me great pleasure because, like I said, that people know. I grew up a fan. I'm sick and tired of seeing my childhood heroes die early and then not knowing whether their families had any reasonable means of support thereafter.
So I think you can see Andrew Yang puts it out pretty succinctly, and he's very passionate about it. And he's had this message in a number of different places, and I have to believe he's going to try to make it happen. Can he? Will he? We'll find out. We don't even have a for sure result of the election yet, so we don't even know if Biden's going to be the one who can tap him to do that, or have connections to him to let him do that. It appears that's going to be the case, but we don't know yet. There's also an IRS form 8919, the uncollected Social Security and Medicare tax on wages form. And this is used by workers who believe they're being improperly classified as independent contractors by an employer to figure and report the employee's share of uncollected Social Security and Medicare taxes due on their compensation. So this is something that any performer could do. Maybe they have done, and they could have asked the IRS, particularly if they did it in mass and said, hey guys, let's all do this. Let's all file this form because we don't think we are independent contractors. Now, I don't know that procedure, but I have to imagine that WWE would find out who those people were, and then you have to believe there'd probably be repercussions, or they get shut down and the IRS reviews it and says, hey, we've tilled this ground before. There's nothing new here. That's their status is what it is. You're an independent contractor. See you later. Thanks for filing. That's a possibility, and not one I've heard being bandied about or talked about as a potential solution. As Zelina Vega will tell you, another interesting and very promising thing that people, talent, could do to be considered an employee and not an independent contractor is to join a union, to create a union. Now, creating a union, well, we'll talk about that in a second. One union that gets brought up a lot is the Screen Actors Guild, the SAG-AFTRA union. So that's the Screen Actors Guild, or American Federation of Television and Radio Artists. They are a labor union for performers. Could lead to residuals for wrestling. Wouldn't that be interesting with networks? But there's only two ways in which you can be a member of SAG-AFTRA as it stands today. One is you could have employment under an affiliated performers union, and those are all enumerated. So there's ACTRA, which is basically the Canadian SAG. There's the AEA, or Actors Equity Association, for live theater and not TV and film. There's the AGMA, American Guild of Musical Artists, for operatic, choral, and dance artists. There's the AGVA, American Guild of Variety Artists, for live stage performers without a script or storyline. So vaudeville, cabaret, circuses, things like that. You'll notice Wrestlers Union isn't one of those. So if there were to be a union of wrestlers, if they were to form a union, which I think is probably not tenable, I think you'd have enough people resisting, enough company men and women, if you will, that wouldn't happen. But if it did, they could be affiliated, get themselves affiliated with SAG-AFTRA. According to tweets just today that have made the rounds on the internet, SAG-AFTRA is interested in helping professional wrestlers. They're interested in what Zelina Vega had to say. But getting the wrestlers to agree to do that, to create a union, might be tricky. So how does the other way? I said there was two. What's the other way to be a member of SAG-AFTRA? Well, that's proof of a Screen Actors Guild or AFTRA employment with a studio and in SAG-AFTRA based on a collective bargaining agreement. So for that to happen, there'd have to be a collective bargaining agreement between SAG-AFTRA and WWE, AEW, Impact, or one of these. Well, what are the chances of that? What are the chances that Vince McMahon or Tony Khan or somebody wants to have a union discussion and a collective bargaining agreement kind of dictating what they do, how they do it, how they pay with a wrestling company? I think slim to none. But if they were to do it, there are things built in that are very much parallels between film actors and TV actors and wrestling. Not everybody's the same, right? Brad Pitt is Brad Pitt, and he deserves to get paid more and be treated a little differently from me walking on set and becoming an extra. You're not guaranteed employment, right? It's the nature of the industry. It's the nature of how things are done as to whether or not you're going to be employed. And a lot of it has to do with talent and your appearance and things like that. Boy, that sure sounds a lot like wrestling. So it would apply, and it wouldn't necessarily be, oh, everybody's got to be paid the same amount and have the same contract and all of that. No, I don't think it would. I think they would have very much parallels with SAG-AFTRA, and all of that could be pivoted or adjusted for professional wrestling. But there's not going to be collective bargaining with those companies. So what would happen? What could we do? Well, I think SAG-AFTRA would have to, and I don't think it would be that hard, maybe make a third class of qualifying for their union. So that way people could join or not join based on their own beliefs, their own decisions. And the more and more people you have join, the more powerful they would get. If you can't get a lot of people to join, there's going to be repercussions against them. But again, there's union rules and laws and things that have to be adhered to. But that's the only way I think you can get some agreement. And then you're going to have a big name, somebody is going to say, you know what, we aren't being treated right. We need to have collective bargaining. We need to have the treatment of healthcare, that we can all get and all be taken care of, pensions and things like this. And I'm going to do this and cross that line. And, even with the Screen Actors Guild, not everybody has to be union. Their union preference is given. And there are certainly a lot of non-union folks that are used on movies and things like that. Extras. I've been an extra in a movie. I'm not in any Screen Actors Guild or anything union. So you could have that for extras, for your enhancement talent, for people that just show up as background workers. And Adam Rose's parade of people that are behind him, his rosebuds, if you will. So that's a possibility, but I think that SAG-AFTRA would have to agree to adjust their bylaws, adjust their rules to apply to pro wrestlers. Maybe I'm wrong. Maybe the wrestlers will decide, get together and unionize and become affiliated, and then it's an easy way in. But absent a change in the status initiated by a wrestler or former wrestler with the IRS, absent a review by the National Labor Relations Board, or a change in the SAG-AFTRA rules of eligibility, again, probably narrowly tailored just for professional wrestlers and maybe somebody like the American Gladiators. There's a lot of character-driven stuff there, but it is performance. But it wouldn't be American Ninja Warrior, because while it may be somewhat scripted in what the people are talking about, and maybe situations to add drama and things like this, I don't think it's scripted. I think it's true performance. But if the SAG-AFTRA wanted to modify their rules, modify their bylaws, and do something to narrowly tailor for sports entertainment, I think that's the way they're going to have to go. What might need to happen is somebody challenges contracts that are similar to WWE's. I'm not aware of any that are as restrictive as theirs, but there might be some, or maybe some company is going to get there because they are, in my view, getting more restrictive. But until they get there, I don't know that everybody's on that same footing. In fact, I know they're not on the same footing as far as promoters and being challenged by a worker as being an employee versus an independent contractor. But if you had another company, not WWE, that had a WWE-like contract and that got challenged with the courts and that got overturned, well, then you have something that could be precedential or at least could be cited in case law against the WWE. Or unionize, right? That's what I think is going to have to happen for folks to be treated less like independent contractors and more like employees, if that's what they want. So what do I think? What seems fair? What seems reasonable? It sure seems reasonable to me to maybe have a new class of statutory employee or an agreement by the companies, even if having a statutory employee, remember that's an independent contractor that is treated kind of for tax purposes as an employee, have part of their taxes covered by the company, by the promoter, by the employer. Saves them some money, which is a win, but then also get some pressure and get a legacy fund, right? Pressure the larger companies and future companies into a legacy fund, some sort of healthcare reimbursement for common injuries. So I think with the NFL, they have a table, some actuary probably put together that says, hey, if you were in the league for 3 or 4 or 5 years, these are the type of injuries. This is the level of payout you would get. So if you were with company A, WWE, AEW, whomever, NWA, if you're with company A for 2 or 3 years, here's the kinds of healthcare reimbursement you can get. Here's the sort of legacy fund, things we will pay out for things, maybe limit the scope. Things that are like knees and ankles, backs and necks, maybe CTE related if you want to go there. Substance abuse help. Certainly WWE's been amazing by all rights and accounts at helping folks with substance abuse. But isn't it time to help those guys that have beat up their bodies and can't walk and whose knees, they didn't want to lose their spot. And so they kept working on a beat up knee and ground it down to nothing and can't walk. What if we had that? Would there be less argument? Would there be less debate? Would there be less unhappiness maybe with talent that they're not treated the same if there's a legacy fund? If we helped the guys who paved the way, because you got to feel bad for some of these guys. Just watch the movie The Wrestler and look at that. And that in some instances is real life for some of these guys. Wouldn't it be great to have a legacy fund, to have some kind of healthcare reimbursement and maybe some way of helping people save and invest for the future and not blow through what they've got now? Seems like it makes sense to me. And billion-dollar companies, well, they can do that, right? We know that they can do that. Again, my buddy John Oliver, I think he said it best.
Yeah, those years meant a lot to fans. That's why they want him and other wrestlers to be taken care of. There've actually been multiple GoFundMe campaigns to cover both healthcare and funeral expenses for wrestlers that fans have stepped up for, which is heartwarming, but frankly, fans shouldn't be the ones shouldering that responsibility. Here's how bad it is. Even the NFL, for all its massive faults, now offers players health reimbursement accounts and have established a legacy fund for older players who may be dealing with health issues. And when you've lost the moral high ground to the NFL, you are morally subterranean.
So that's all I got. What do you guys think? What are your thoughts? I've laid it out the best I can, but it's really up to you and up to the talent to draw your own conclusions. Are they independent contractors or aren't they? I think at the end of the day, really all that matters is what the IRS thinks. I don't know that the contract and what somebody agrees to with no position of negotiation thinks really matters. Certainly the court before has said that, but the business has evolved. The business just isn't the same now as it used to be and hasn't been the same for quite some time. And I don't know that somebody has had any money or resources or the wherewithal to kind of cut off the hand that's been feeding them by challenging this. And there's upsides to challenging it, and there's downsides to challenging it. Really, it's going to come down to what the talent want, what they believe, and what's important to them. But I'm interested to hear your thoughts. Any questions you've got, any comments. You can reach me at Gimmick Attorney on Twitter and on Instagram. You can see my professional bio at gimmicattorney.com, which goes back to my law firm of Shoemaker, Loop, and Kendrick. And thanks for listening. I hope you found it interesting. I hope you learned something, and hope to hear from you guys, and we'll see you again soon. And certainly I've done this. I've done public speaking a lot, many times. There's certain presentations I've done that I've done so many, I could do it in my sleep. But this is my first time rolling a podcast solo. So I hope to be better. I'll do better next time. Until next time, this is Mike Dockins on the debut episode of Wrestling with the Law, right here on Ad Free Shows. Thanks.